Good afternoon, everybody, and thank you for joining us today. The internet is heading to the Supreme Court. We have seen Supreme Court justices argue the last 2 days, two different cases, the Gonzalez versus Google case and the Tamanov versus Twitter case, in which they're examining where Section 230 might go. The Section 230 law, for those who may not know, is the liability and immunity law that protects online platforms from lawsuits. And there's been a increasing push in Congress to refine that law. And today we are looking at a panel of experts to take a look at the oral arguments that happened yesterday morning and this morning as well. But the reason why it matters is that, when Section 230 was first enacted in 1996, it was a very different type of internet. Today, we have algorithms that help moderate content, help provide recommendations, and help screen out negative things online. And so at play right now in these two cases is whether or not those algorithms fit within the Section 230 bounds of the law. And so as a public policy person, I'm very much interested in the congressional reasoning behind the reforms to this law. But with me today, I have a lot of legal experts. And if I can just go ahead and introduce them, we'll hear from them today. I do want to encourage folks, if you have any questions, please feel free to tweet us at hashtag BBC Live. Also, you'll find the comment section. We'll try to get to them in the last 15 minutes or so. I'm sure there's plenty of questions that you'll want to ask these great experts. But with us today, we have Angela Campbell, who's professor of law at Georgetown University. Eric Goldman, who's associate dean and professor at Santa Clara University School of Law. And Ashley Johnson, senior policy analyst at the Information Technology and Innovation Foundation. So welcome to the panelists today. And I'll just go ahead and get started with Professor Campbell. What are some of your impressions from the arguments that happened today in Gonzalez v. Google?
Well, I thought the most interesting moment came at the end of Google's argument when Justice Jackson asked counsel whether she was aware of any defamation claims in any jurisdiction in which Google would be held liable for its organizational choices. And her answer was something to the effect of, no, I'm not worried about the defamation claims. I'm worried for products liability claims, or what the government kept saying, your design choices. These could be a product liability claim or negligence claim, like you negligently featured content that made my kid addicted to whatever it was. So I think this is sort of at the nub of the case. They're trying to use something that was intended, actually the law was intended in part to protect children and promote diversity, not to allow defective products and harmful products to be put on the market without testing or with actually intention of causing harm. And right now, Google is in fact facing Google and Facebook and TikTok are facing a multi-district court litigation in California that relates specifically to their products being designed to be addictive for young people. So that's what I think they're trying to use Section 230 as a shield for something that it was not intended for at all.
Got it. So it's your impression that the Section 230 needs to be reformed, and this is one way to do it?
Certainly. It's one way of sort of focusing the courts back on what Section 230 actually says and what it was actually intended to do, and not just giving them a get-out-of-jail-free card for anything they do.
Thank you, Professor. So I'm going to turn it over to Ashley. So Ashley, what were your thoughts from yesterday's oral arguments that the justices had?
I think the first thing, the most overwhelming thing that I noticed, and I heard multiple justices point this out as well, is how difficult line drawing is going to be in this case. There were so many questions from multiple different justices to both to Eric Schnapper and to Lisa Blatt on hypotheticals of, okay, so if we drew the line this way, who would be liable? Would this, who would fall under this immunity? If we drew it this way, what would happen? If we drew it this way, what makes this case distinct from this case? I think that was those were all very insightful questions from the justices, and I think it highlights how difficult line drawing is in these Section 230 cases across the board. And that's something that I've written about a lot in my work, and that I've seen a lot of other Section 230 experts talk and write about.
Yeah. So the justices were struggling with some of the where to draw the line. And when you say that, I noticed there's a lot of hypotheticals put out there. Did you notice that, any hypothetical situation really kind of add to the this idea that, there wasn't great clarity as to where to draw the line?
I think the most common hypotheticals that I saw brought up that I noticed personally were involving search engines and search engine results, because obviously those rely on algorithms to make recommendations. There's so much content online, and in order to effectively search through it, you need algorithms to sort it for you. And so I think those hypotheticals were bringing up some very important points on how the Supreme Court, if it does decide to draw any lines in this case to narrow Section 230 liability in any way, it needs to be very careful about potentially drawing a line in a way that would have a lot of negative consequences for the online services that we all use in our daily lives.
Yeah, for sure. I did notice that there was quite a bit of discussion from different justices about the economic impact potential on this. But I want to go over to Eric, Professor Goldman. Same question. What were your general takeaways or thoughts of yesterday's oral arguments?
In general, I think that the justices were confused why they even took the case. There wasn't a circuit split to address. The arguments that the plaintiff made were really, really weak. They just weren't credible. And so in a normal Supreme Court case, you would expect that there's going to be two zealous advocates, each anchoring extremes of the position and giving the justices something to navigate between. But the plaintiff's arguments were so weak that there wasn't an anchor on that side. They didn't know what to do with that. And I think they were then second guessing why they were even taking this case. That gives them some reason to think about alternatives to actually ruling on Section 230, depending on what they do with the companion case in Tomna. But if they do go down the Section 230 path, I certainly didn't hear by vote in support of the plaintiff's position. So the question is, how will the opinion read, and what kinds of caveats are they going to add to what should be an otherwise clear Google win?
Yeah. So let me ask a follow-up question on that for folks that may not be as familiar with the process. If the Supreme Court decides, this is not the case, they want to look at Section 230, what are their options? Do they just, dismiss it on cert? Do they have split decision? What are some ways that, potentially, if what you say, Eric, is, they don't know why they took this case or they're second guessing it, what are some possible avenues to kind of delay their ruling on this?
The most obvious one is that they could dismiss a case on the basis that either it was improvidently granted or that there are now questions that need to be answered in the first instance by the lower court. And so they send it back down, or they simply dismiss the case entirely and essentially uphold the lower ruling. So I hope they don't do that, only because Section 230 is coming right back at them at some point, and probably not that far in the future. So they've already done the work to try to understand the statute and to figure out where they stand. It would be, I think, a bummer then to just basically kick the can down the road for another X number of years, leaving a cloud of uncertainty over the field. Then again, whatever opinion they write is going to create probably some new uncertainty. So we're kind of in a catch-22 on that front. They really shouldn't have taken the case in the first place. Once they did, they gave themselves only potentially not great options.
Yeah. So this next question is for Angela. If the case gets dismissed, or you mentioned there's some reform efforts around Section 230, do you see Congress potentially taking the mantle up on this? What do you think the impact of this case would be on Congress?
That's really hard to predict. I think it would certainly create more calls for Congress to step in and kind of. I think actually a lot of amicus briefs on both sides, but particularly the ones supporting Google, said, this is an issue that Congress should decide. Justice Kagan made the point that, and this is the one line that got a lot of laughter, that we're not experts on the internet. And so wouldn't it be better for Congress to deal with this? Well, I don't know that Congress is an expert on the internet either, but I think there will be more pressure. And there was a hearing on February 14th before the Senate Judiciary Committee, where Senator Whitehouse said something to the effect of, I would bet that if we took a vote today on the flat out just repeal of Section 230, it would pass out of the committee with probably no objections. And what we can't seem to agree upon is what add-ons we want in addition to that. And so, I'm not sure that that's actually a better result, quite frankly, to just an out repeal of Section 230 rather than to have a more narrow and normal interpretation of what publication entails.
Yeah. So. And Eric, I want to turn it over to you real quick. So in past work, you've mentioned, there shouldn't be necessarily much done to Section 230. Do you see Congress potentially taking some of these arguments and making reforms, or do you think that your position remains unchanged where, Section 230 should remain as is?
So the entire debate about Section 230 has become partisanized. Each party views a reform to Section 230 as advancing their partisan agenda to the expense of the other partisan side. In a situation like that, there's not a lot of opportunity for good policy outcomes. And so I think we're not only stuck with partisan gridlock, but actually we're exposing the fact that the partisans see the situation differently, in part because there are no what I call Pareto optimal outcomes from here. There's no way for Congress to amend Section 230 that will make some people better off and no one else worse off. They could certainly amend it to make some people better off and other people worse off. That's a policy trade-off or balancing act that Congress is far better positioned to do than the courts are. But because there are no Pareto optimal options that are available, only trade-offs, I think that we can see why the partisans are never going to agree with each other, not only because they're viewing it as a partisan battle, but because they know whatever they're going to do is going to have some opposition because of the group that's going to be negatively affected. So I think Congress's paralysis actually, if we can get rid of the partisan veneer, is actually a symbol of how important Section 230 really is. It's given us an option that might be the best of the options we have available. We might not like that option, but I also think we wouldn't like any of its alternatives.
That's an interesting point. And Ashley, I want to kind of kick it over to you. Did you see in terms of your interpretation of the argument? We have a question from the audience. Was it the plaintiff's arguments were weak, or do you think they were kind of ineffective?
I do think there's a little bit of weight to either side of that question, depending on how you interpret it. I certainly didn't think the plaintiff's attorney was very effective in arguing their case. I think the multiple justices at different points brought up arguments that I thought were more compelling than what he was currently focusing on. Sort of trying to guide the conversation in that direction, that usually didn't end up working out. And so I could see that the justices saw some legitimacy and obviously some something compelling in the arguments, the written arguments that they'd received that they weren't necessarily hearing in the oral arguments, which I definitely think was a sign that the plaintiff's attorney was not doing as effective a job as he could have done. So yeah, I would lean more toward the latter option in that question. I think he maybe was a little bit out of his depth.
Thank you. And I want to also ask the question, were there any surprises in how the justices responded to the case? You generally think of Justice Thomas as being kind of the critic in the room around big tech and Section 230. That may not have been the case based off of some of his questioning yesterday. Were there any surprises or alliances that y'all saw yesterday in the questions, or anything surprising about how the justices approached their questioning? And I can start with Professor Campbell?
Yes, I was also surprised that Justice Thomas didn't. He seemed very skeptical of the petitioners, even though he had indicated in previous dissents that he thought a Tier 30 case needed to come to the court. As far as other interesting alliances, well, I thought Justice Jackson asked some really good questions, really probing questions. She and I would say Justice Kagan and Justice Barrett were very concerned about discriminatory impacts of algorithms. That really wasn't something that the council addressed very well. I thought there was also some cross-party or orientation, like both Justice Kavanaugh and Justice Kagan were concerned about economic disruptions if the law were changed and that sort of thing. So yeah, it's hard. It's very hard to see how the justices are going to fall out, and probably not necessarily along the traditional liberal conservative lines.
Yeah. Professor Goldman, did you have anything you wanted to add to that, or any other surprises you saw?
Yeah, obviously, oral arguments are a chance for the justices to get answers to their questions, including maybe also make points for other justices or to explore theories that they're going to not pursue in the end. So I didn't read too much into what Justice Thomas and Justice Alito asked as signaling that they're clearly skeptical of the plaintiff's claims, though their questions did support that. But certainly I was surprised to see them take that tact when, given some of the work that they've done in the past, it seemed to suggest that maybe they were excited about a chance to reform Section 230 judicially. I would call out Justice Jackson's questions. To me, actually, I didn't think that they were as laudable as maybe Professor Campbell did. I thought that they actually seemed somewhat underinformed, and they made me nervous, frankly, that they were just marching to a different drummer than the other justices. And I don't know if, again, that was her exploring stuff or if that was a true portrait of her position. And I'll also note that Justice Gorsuch, I thought, also was an outlier. He kept advancing a theory that had been advanced by the amici involving a particular interpretation of the term access software provider in the statute. I don't think that that's the right term. I don't think that that's going to bring any other justices along. And so seeing him advancing his theories on that, which nobody else, I think, really wanted to engage with, suggests that he might also be, owning his own particular corner of this issue.
Interesting. And I want to give Ashley an opportunity to also answer the question, but pose a kind of a tag onto that, Ashley, in terms of what Eric just mentioned. Something to the effect of not being as informed, and in all respect to the justices, the leading minds of legal scholars here, in terms of their technology understanding. Was there anything concerned? I mean, I heard a couple of times, was mentioned, they're not internet experts, and there's not quite a technical expertise. Is that a concern on kind of how the court's going to rule on this case?
It is a concern. It's also, of course, a concern, I think, as Angela brought up earlier, even when Congress is taking a look at Section 230, they don't necessarily have that technological expertise either. So that's a concern that we're pretty familiar with by now. Certainly not a new one. There were some instances during the arguments when I noticed the justices displaying, an understandable lack of complete and thorough expertise on technological issues. It's not their job to have a complete and thorough expertise on technological issues. They're legal experts, as you mentioned, not tech experts. For example, I can't remember which justice it was who referred to Section 230 as a pre-algorithm statute, and we're trying to analyze it for a post-algorithm world. Algorithms did exist and were used on the internet before Section 230's inception, but it is true that they weren't as ubiquitous and advanced as they are today. But small discrepancies like that were the sort of things that I and other more tech-savvy people noticed when listening to the oral arguments.
And just taking a quick step back, because since we have folks that can really speak expertly to this, Can somebody from the group really explain the difference between the First Amendment and Section 230 issues as it relates to this case? Eric? Eric just had his
I'm
hand
going to
up.
volunteer on this one only because that was the point of my amicus brief. So I don't know if this was an intended softball or I'm just pouncing on it. The First Amendment really didn't come up in the oral arguments. And I think generally for good reason. This is not a First Amendment case. This is a case involving statutory interpretation. Congress created a law that sits on top of the First Amendment. It supplements the First Amendment. And the entire scope of the analysis for the Supreme Court is to figure out what did Congress say that adds to the First Amendment. Now, of course, Congress couldn't derogate the First Amendment, though that wasn't really an issue in this particular case. So, there was no reason to talk about the First Amendment because of the fact that this is purely a statutory question. I explained in my amicus brief how were Section 230 to be carved back, defendants would then invoke the First Amendment as a fallback defense. But I tried to explain why that doesn't work as well as we might expect, because Section 230 as a statutory a supplement to the First Amendment creates what I call a procedural fast lane for defendants. It gives them the ability to resolve cases with more certainty and at lower cost than if they were to invoke a First Amendment defense. So one of the things I wanted to do was to explain to the justices that if they were to think that they could carve back the Section 230, but the First Amendment will gap fill, that actually that's not likely to work the way they would hope.
Okay. And Professor Campbell, is there anything you want to add to that?
Yeah, I would add. I mean, I don't disagree with what you said per se. I just had sort of a different take on it, and that is, in Section 230, we have given certain more protections than the First Amendment itself provides to one subset, that is to interactive computer services, that we don't give to the traditional media. And so it seems like 230 is immunizing. It's very hard to make a defamation case against traditional media because we have protections. But if you are not, Google instead of the New York Times, you can't even have a case brought against you. And I'm not sure why that is necessarily a good thing. I can see for small providers and just the third-party content providers, maybe they need some protections, but I think it's really overboard in terms of what it gives. It's more than we give to any other media. And why should these huge social media platforms have so much power and not be subject to the same law as everybody else?
Great. Well, I guess the question I have to follow up on that, Professor, is, there was, at the time, this idea of the sword and the shield with Section 230. The idea to protect those in the crib essentially, or those startups from liability protections or liability or from being sued in liability defamation lawsuits. And I guess the question is, do you still think that Section 230 with the kind of big tech industry that we have still serves that purpose for the smaller, medium-sized ones, or is there going to be an obstacle if we change it for those folks to enter the market?
Well, I mean, I think you have to go back and look at the purpose of the bill, and there were several purposes, and one was particularly dealing with these defamation claims. But another part of it was part of the Communications Decency Act, and there were ways. So there was part of that bill that actually prohibited showing indecent content to minors. And that part was, I think, properly struck down as being a violation of First Amendment. But another way was to provide this Good Samaritan protection to essentially give incentives to internet service providers and computer services to police their own content. And it gave them liability if they took down content from claims that they shouldn't have taken it down. But I think it's gone way beyond that original purpose, which was to give, to encourage this moderation and it's become a shield for the and the big company, not just the small companies, but the big companies say we don't have any liability even for everything we put up, even if we don't do any moderation. And I think it's really, I don't think it's serving the original intended purpose in that way.
Interesting. Ashley, I'll turn it to you. Do you, in terms of reform to Section 230, do you think it's still serving its original purpose, or what are your thoughts on what Professor Campbell said?
I certainly think that Section 230, for the most part, is serving its original purpose. I mean, we heard during the oral arguments, and we've heard over the debate over Section 230 for the past several years, many people speculating about what Congress intended. We know exactly what Congress intended. The two members of Congress who wrote the bill wrote this section are still alive and well today, and very able and willing to give their thoughts and comments and what their thought process was and what their intention was when they originally wrote Section 230 to add to the Communications Decency Act. Angela touched on some of those intentions. Some of them are written into the language of the bill itself. So we know what the intentions are. People who in the debate try to add this kind of mystery of, oh, we don't know what Congress intended. That's not true. We know exactly what they intended. And I think most of those intentions have borne out fairly effectively. Obviously, there are problems on the internet, bad things that happen on the internet. I think there is room for Congress, especially, to take certain steps to potentially alleviate those problems. I don't think that necessarily has to take the form of Section 230 reform. And I think that Congress over the past year or so has perhaps begun to realize that there is a lack of regulation, not just in the Section 230 space. We have Section 230, but there's a lack of regulation on issues like privacy, on transparency and accountability when it comes to content moderation. So there's plenty of room for Congress, especially, to improve the internet, to create more accountability, to create more protections for users and consumers. I don't think it necessarily has to take the form of a Section 230 reform. And I think a lot of those other issues often get swept up into discussions around Section 230.
Yeah. So we got another question from the audience, and I'm going to direct this to Professor Goldman, because you mentioned Justices Brown or Jackson's comments yesterday. And the question is, wasn't her questions asking about the plain language of the statute? And she specifically asked, how should we read the text? Can you explain further why her questions were underinformed?
I can. Would it be okay if I just added a few remarks to the prior colloquy? I just had a couple of things I wanted to add on that.
Absolutely, yes.
Just to clarify, so Section 230 was enacted as part of the Communications Decency Act, but the way Congress did it is it actually combined two alternative proposals that were each trying to solve a problem about how we encourage the right kind of content moderation and put them together. So they weren't intended to be coherent. They were actually intended to be alternatives. And that has been a source of continuing confusion even to this day. Ashley mentioned that the authors of Section 230 have expressed their opinion about whether or not the law still works today the way that they had hoped back in 1996. And in particular, Representative Cox, who has been very clear about the fact he always expected that we needed Section 230 more as services got bigger. As they had more content moderation to do, they needed the additional liability protection to basically try and fail. That they couldn't bat 1,000. The larger the numbers were, the more that they were going to have some error rate. And as a result, Section 230 was going to be needed as a scale. So in fact, we know from Representative Cox that actually the mechanisms that he designed were exactly what he doing exactly what he intended today. And the last thing I'll mention on that point is that Section 230 still keeps the door open for new entrants into the marketplace. And that might sound weird because Google and Facebook have eaten up so much of the industry that we think they're the end game. But in fact, in the US, we have a robust ecosystem of small players, many of whom you may not be familiar with because you're not the targeted user. You're not the intended audience for that particular conversation taking place. But all of us are engaged not only with the big players, but with some smaller players as well. If you look at other countries, they don't have that kind of robust ecosystem. They have basically only the incumbent giants and none of the small entrants as well. And Section 230 is, I think, the primary reason why we see that dichotomy. Now, the question that you asked me a few minutes ago that I will now answer is, what was so confusing about Justice Jackson's remarks? And there were a few things that really stood out, but the fact that she tried to do a plain language interpretation of the statute was interesting, only because there's a very long history of precedent of interpreting the plain language of the statute that distilled into a 3-element test that she rejected, but that almost every other court unanimously across the appellate courts has adopted. And in fact, Congress at a couple of points in this juncture has ratified the way that the courts have interpreted Section 230. Go back to the 2002 act involving domain names, where they said, we are ratifying what we've seen in the case law about Section 230 to date. Or when they passed the Speech Act, they extended Section 230 to apply to foreign claims that might conflict with it. So Congress has already said that the courts are getting it right. So for Justice Jackson to say, I got a whole new way of reading the statute after 26 years was just really weird. The other thing that she did is she implied that Section 230 only applied when plaintiffs were making strict liability claims. If they were alleging any scienter on the part of the defendants, then she was implying that Section 230 implied. And that just cannot be right. There's no possible way to read the statute on that. So I'm a fan of plain language reading of statutes. I think that is the right approach. Justices know that. They're very good at it. And for her to suggest that somehow that was taking her a different direction was just really shocking to me.
Interesting. So I want to give Angela a chance to potentially respond to that, but also ask her a question. In terms of a lot of the proposals or a lot of criticisms are focused on the algorithms. Do you think that there's proposals, like why is algorithms the ire of both Congress and Supreme Court at the moment? Can you explain why that doesn't necessarily, why it's rose to the Supreme Court, but also a chance to respond to Professor Goldman if you'd like.
Well, I won't say too much about Justice Jackson. I interpreted what she was trying to do was to go back to the sort of the case law that Section 230 was intended to overturn, the Prodigy case, and really focusing on the Good Samaritan aspects and focusing on defamation as being what they were mostly concerned about, not all these other potential injuries. So, we can agree to disagree on that. I think people don't understand algorithms very well, and I think algorithms are not in the problem themselves. Algorithms can do good things, they can do bad things, and they are necessary. I think that what the problem is when algorithms are designed to take advantage of human vulnerabilities, and particularly my concern is vulnerabilities of children and teens who don't have the brain development. Their brains aren't fully developed, and they don't have the self-control and they're feel very rewarded by small rewards and little dopamine hits that you get, which they engineer into the way they try to keep people online as long as possible, not because they want to, and this is not in all cases. And this is why I think it's problematic that the Supreme Court thinks of social media platforms as a search engine, because they do a lot more than just respond to searches. In fact, many times they're not responding to searches at all. They'll just start showing you videos, and then based on how you respond to that particular video, they'll show you more and more videos. So they're not where someone's just searching for information and they're getting it. They are putting out stuff that's intended to keep you there as long as possible and to get as much data about you as possible. And they can then use that data to refine what they serve to you, both in terms of advertising and content. And that's what I think people find very scary, but they don't really understand it. And so that's why I think the algorithms are the product design or part of the product design that the social media platforms, and that's why the focus in when does that become more than simply necessary to provide the service to we're actually causing harm because of the way they've designed those algorithms.
So can I pull on that thread a little bit, Professor? And we've seen in Congress a big push towards a national data privacy law, potentially a little bit of stall on that. But, in the current House and in Congress, you start seeing some pushes for a children's data privacy law or data privacy focused on children or young minds. How would potentially the proposals for reforming Section 230 and kind of this Supreme Court impact the ongoing kind of negotiations or push for data privacy legislation that are more narrowly catered towards children's data privacy?
I'm not sure that there has that much impact, really. I mean, there were two bills last term that went pretty far. They didn't get through the. One was the Children's Online Safety Act, and the other was an update to the Children's Online Privacy Protection Act. Both of them have some really important provisions. Like, for example, right now, once you turn 13, you have no privacy protections. And so they would extend those privacy protections up to, I think, age 16 or 18, depending on which bill you're looking at. I think having an overall privacy where everybody has privacy protections would help a lot. But children still need their own special protections because, as I said, they're much more vulnerable than adults are because of their normal brain development. And we know that kids are spending, I think middle school kids on average 5.5 hours a day on social media, and teens up to 8 hours a day. And that's just so much time, and it's having so much impact, and we're having a crisis in mental health. And while it's clearly not the only cause, it is a big contributing factor, and something really needs to be done about that. But I don't know that Section 230 is going to address that problem. I think there's a whole host of other things that need to be done, such as passing bills like COSA and COPPA, and also, providing more mental health resources and that sort of thing.
Right. So I want to turn to Ashley. Do you have any thoughts on, specifically catering Section 230 so that, potentially a children's data privacy law would, have different regulations to it? Or, have you done any research in that space?
I would actually agree with a lot of what Angela said. I think that I agree that children and minors in general are a more vulnerable population. They sometimes require a different set of rules or regulations. That's what we currently have. We have COPPA, the Children's Privacy Law. We don't have a federal privacy law that protects all Americans currently. Obviously, that's a huge gap that hopefully Congress will continue to work on resolving. But I agree to what Angela pointed out, that these issues aren't necessarily best settled with Section 230. We need separate approaches to them. There are a variety of different approaches. Privacy is, of course, one of them. And again, I mentioned there's a big gap there. Again, I earlier mentioned transparency and accountability. I'll mention it again. I think those are two areas where we've seen bills that have touched on how to increase transparency and accountability around content moderation and other things that online services do that are currently sort of under transparent, under accountable. There's a lack of transparency and accountability in a few different practices. And so, I'll just mention that again because I think it's something that Congress has started to explore, but I hope they'll continue to explore it in the future.
Yeah. So you've mentioned this, and then a lot of the briefs mention, ours including BPC filed an amicus brief around the idea that Congress should be doing the legislation around this, and the court shouldn't circumvent that process. But I have a question for Eric on that front. In terms of the proposals you've seen in Congress, is there anything that you think would jive with some of the positions that you have taken in terms of protecting Section 230?
So I actually like the way that Ashley framed it earlier when she mentioned that to the extent that there are problems that need to be addressed, they're probably not best addressed through Section 230, but by identifying that problem and then coming up with a custom crafted solution. Like my co-panelists, I do agree that we need a federal privacy law. I might have different terms for it. I think the number one thing we need is a preemptive law that that eliminates the variations in state privacy laws that we're seeing that I think are really not helpful to anybody. But I would agree that if we think the problem is privacy, then let's fix privacy on its own terms. Coming up with some kind of backdoor way of getting Section 230 to do that is really not the right approach. And so many of the bills actually have tried to link Section 230 reform to some other concern. So take, for example, the idea that maybe we could combat opioid addiction by changing Section 230. That's like such a backward way of thinking about it. It's opioid addiction is the problem. Let's talk about what we need to do. And then perhaps at the end, we conclude that Section 230 is a contributing factor, but odds are there's going to be a dozen, 24, 1,000 things that are going to be more likely to be contributing to the problem than that. And we're wasting our time by then focusing on opioid addiction by talking about Section 230. So I really think centering the question on what harm are we trying to resolve or remedy gets us closer to the answer. And that's usually when I'm in press interviews or in panels like this, I often get statements, something like the fact, we all agree that there's problems on the internet that we need reform. And I say, slow down for a moment. That might be true, but if we aren't talking about the exact problem and agreeing upon that, we're probably talking past each other. And I see that too often.
Yeah, definitely. And for folks that are still tuning in, please send us your questions, hashtag BBC Live. You can use the YouTube comment. Very much would like to address those in the last couple of minutes. But I'm going to kind of pull an audible on this one and ask a question that I don't know if the folks are prepared to answer, but that is, if the courts decide to rule in favor of the Gonzalez family, what are some of the impacts that you think might happen across the board? Would it change business models? Would it change moderation on these platforms? And I'll start with Ashley.
Sure. I think, as I brought up in the beginning of this discussion, it really depends on where the Supreme Court decides to draw the line when it comes to immunity. We know it likely will have something to do with algorithmic recommendations, but as many justices brought up in the oral arguments, there even within that subcategory, there are so many different places where they could decide to draw the line, and I think the consequences will all depend on where they draw that line. Regardless, I think we will likely see online services having to change the way they moderate in some form or fashion, or maybe change the way their algorithms work, change the way they use algorithms. I don't see a future where online services, especially ones that deal with massive amounts of content, stop using algorithms altogether. I just don't think that's realistic. And I certainly don't think that would ever be the Supreme Court's intention. Again, it so much depends on where the Supreme Court draws the line. Even if they do rule in favor of the Gonzalez family, they still have so much leeway in their decision making.
Yeah, and we hear every opinion out there, from the sky will fall till nothing will change. Angela, I wonder what your opinion is.
Yeah, I mean, I think it depends on how broadly or narrowly they write the decision. I mean, this case is hard for me to actually understand because it really has to do with this terrorism act. And so it's not clear to me how broad I think it would probably, at most, they'd send it back to the lower court for them to be able to make their case. And, who knows what happens. I would say two things kind of related to what we've been talking about. While I agree that Congress should be addressing the problems that I see about youth mental health and the role of social media through some method other than Section 230, there is a connection, and the connection comes up in two ways. First of all, most defective products get taken off the market or made safer because there are lawsuits brought. And what Section 230 here is doing is preventing any of these private lawsuits for people, for families that have had really serious suicide, children committing suicide and that sort of thing. They can't get any relief. Now, they're not going to win in all those cases, even if it were changed. But but right now that possibility doesn't even exist. So there is no incentive for these companies to make their products safer. The other thing is that Section 230 can come up in government actions and policy actions as well, enforcement actions, for example, by the FTC. There are two FTC cases not involving children, but where companies claim the FTC couldn't enforce the law because of Section 230. Now they lost. The FTC won, fortunately, in those two cases. But I know from my personal experience, oftentimes we've brought a complaint against YouTube Kids, and the FTC's questioned us, well, can we do anything about this because of Section 230? So it does affect government policy and enforcement of existing laws as well as private lawsuits.
Interesting. And so I'll turn it over to Professor Goldman. Thoughts on whether the sky falls or business as usual?
So I'm actually not going to answer your direct question about what happens if Gonzalez wins, because I don't think that that's likely to occur. But even if Google wins, we might still see all the parade of horribles that you've been warned about. And there's actually a couple of different ways that can play out. One of the most obvious ways is that the Supreme Court can do the kind of waffling, caveating, or hypothetical analysis that is fundamentally what we call dicta. It's not the core holding of the case, and yet it creates this zone of ambiguity that then lower courts have to wrestle with. So it's entirely possible that the Supreme Court says Google wins, but if we had been presented with some other case that they then describe, we might have ruled differently. And what's going to happen is all of the plaintiffs are going to pour into that breach, and they're going to test that speculation or that qualification. It would be shocking if the Supreme Court didn't put in some kind of qualification like that. That's not how they write their opinions. So we're looking at a really unfortunate situation where even if the court is clear about what it wants to have in this case, it's still going to create the possibility of substantial, possibly meritless litigation that is supposed to be what Section 230 is designed to protect. Now, even if the Supreme Court writes the best opinion possible for Section 230, it still leaves open the fact that states and to some degree Congress are nibbling away at the core principles of Section 230. So, for example, there's a pending appeal to the Supreme Court in the Texas and Florida social media censorship laws. Those laws tell internet companies how to do their content moderation operations. That should be precluded by the First Amendment. It should be precluded by Section 230, and that is currently pending before the Supreme Court. If the Supreme Court doesn't take that case, or if they take it and don't rule in favor of the internet services, then the door is going to be blasted open for states to go and say basically whatever they want. So the chances of us preserving the status quo that we have today after the Supreme Court ruling, after the states, and after Congress are done with it is extremely low. And so I do think that we're going to have to contemplate a world without Section 230. And it's not personally a world I'm excited about.
So let me ask a follow-up question on that, Professor. If that's the case in terms of, let's go with states then need to do their own laws around content moderation. We hear a lot with the national data privacy where preemption is a major issue. Is it then turned to Congress to try to create a new national content law of some sort to preempt these states to try to create something of a framework that is workable across the U.S., or is it back to the states depending on where your VPN or wherever you're living? That's what you get.
I'll take the quick answer on this just to point out, depending on the grounds that the Supreme Court rules, if in the social media censorship laws, they say this is the limits of the First Amendment, this is what states can and are entitled to do, it might be that actually Congress doesn't even have a role to correct that, or the states can't correct it because it's now a constitutional interpretation. So when we're playing with the First Amendment, those take away power from the legislatures. Sometimes that's a good thing, but in these particular contexts, that could actually work to the disadvantage of establishing any kind of coherence or any kind of universal standard. Now, as a practical matter, there's no way currently to wall off any particular state and say, I don't want to play by their rules. So at this point, we've got the anarchy that is associated with states saying, you must do this for our residents, but there's no way to limit the technology so that it's only going to be applied to those residents. And that's the kind of thing that Congress ought to be able to fix. I hope they can fix it, but the Supreme Court might actually limit Congress's power to do so.
Interesting. Okay.
I
think, Professor, you're on mute.
Yeah, I mean, one of the big problems here is Congress really is dysfunctional. I mean, they can't hardly do anything. So, and if they do, it's, I agree. There's some people are going to win and some people are going to lose. So it's a really tough problem. I guess, I can see ways that Section 230 could be changed that would make things better. I don't think the current situation we have right now is the best of all possible worlds, but I can also see how it could make it worse.
All right. And Ashley, did you want to respond?
No, I think the other panelists covered pretty much everything there is to say there.
Okay. So we're going to get to audience questions. We have 3 in here. So, but before we do that, I do want to also mention that Supreme Court was having oral arguments with the Twitter Tamina case today. And for folks that may not be aware of how these are connected, I'm hoping one of the panelists can kind of articulate how the Gonzalez v. Google and the Twitter Tamina cases are connected and why they're being heard at pretty much at the same time, a day after each other.
So I'm happy to do that. I would also be happy to defer to my co-panelists. But let me just take a crack at it. The basic complaint is pretty much the same in the Tamina case and in the Gonzalez case. Both of them involve claims that the social media services contributed to terrorist attacks by terrorist groups. The facts of the terrorist attacks differ, and the facts maybe of how the terrorist groups were using them might differ. But they're involving the same basic claim. Now, in the Google case, Google won on Section 230 grounds. So that is the star of the Gonzalez case. Did Section 230 protect Google in that circumstance? In the Twitter case, the court said that there could be an aiding and abetting claim under the Anti-Terrorism Act. And so that particular appeal involves whether or not the Anti-Terrorism Act could apply in this circumstance. So they're dealing with 2 different statutes. The reason why the Gonzalez case gets so much more attention is because if Section 230 is changed, it won't just affect the Anti-Terrorism Act. It could affect basically hundreds or thousands of other claims that plaintiffs might bring. Whereas with the Twitter case, what they say likely could be contained only to the Anti-Terrorism Act and specific statutory language, and that's why people are less engaged with it. First, and like Professor Campbell, I'm not actually an expert in that act either, so I don't even understand all the nuances of it. As well as the holding might be limited to that if it goes against the internet services.
Thank you, Professor. So turning to some of the audience questions, and feel free to jump in and answer them in any order. What are your thoughts about the bills being tried in California and other states around content moderation and algorithmic regulation?
My main answer to any question involve state level bills regarding content moderation and algorithms and anything of this sort is mostly to echo what Eric mentioned earlier and what he also mentioned about privacy. These internet policy issues, in my mind, are best decided at a federal level and regulated at a federal level. As Eric mentioned, there's no easy or really even feasible way for online services to segment their users state by state. And there are very few online services that only serve residents of this specific state or only serve residents of this other specific state. And so these state by state regulations or bills or laws or whatever form they take are a really segmented approach to an issue that affects the entire world, but we can't really pass laws on a global level. So we'll just say the entire country.
Right.
If I could just supplement that, I do agree with Ashley's point. I would also add that whenever I hear the word algorithmic recommendations, I instantly get some concerns that the regulation is going to transgress the First Amendment. Algorithms are a form of speech, and they are a way of curating and or prioritizing speech. So anything that the government does to control algorithms is actually a speech regulation. And for that reason, I also worry that the states are not only reaching beyond their state borders, but they're reaching into free speech issues as well.
Mr. Campbell?
Yeah, I would disagree with that all algorithms are speech. But I mean, there is a problem. The federal, as I said, Congress doesn't act. They're deadlocked. The states are the laboratories of democracy, and the state laws that are pushing the federal law. I mean, I think there are concerns about, it doesn't make sense to have 50 different privacy laws. We should have a national law, but it has to be strong enough that consumers are actually protected, and not just getting rid of the protections that states like California have imposed. So I think they're interesting. And California has also passed the California Age Appropriate Design Code. And I think, seeing how that works, if it's not struck down, it's going to be very interesting and informative. The UK is based on a design code in the UK, which raises the other point that I think we've sort of hinted at, is that the big social media companies, they are operating on a global scale. And so they have to comply with certain, like the UK design code. If they want to do business in the UK, they have to do that. So how they can say, well, we can't possibly do this in the US, but we can do this. We can provide protections to UK youth, but not to American youth, is really not sensible or true.
Okay. Thank you for that. So we have two more questions. I don't think we're going to get to all of them, but who knows? Maybe we'll get through this next one quickly. If the U.S. Supreme Court does not rule in favor of the plaintiff, what are the next steps for protecting our children, our privacy, our safety? And Professor Campbell, I think you're best set.
Yeah, I mean, as I said, there are various bills, and both at the state and federal level, but some of the things that I think could be done, protections for teens, protections for everybody for privacy, ban targeted advertising to minors, make the consideration of best interests of the child a part of designing products, prohibit the use of dark patterns, particularly, I think across the board, but particularly with children who are vulnerable and teens. I think some of the things we talked about in terms of transparency, access to the algorithms to enable researchers to better understand them and to better educate the public about what they are and how they work, and requiring default settings that are most protective of privacy for minors. And also another thing, just simple, but not simple, but effective enforcement of the laws. We have the Children's Online Privacy Protection Act. It's way out of date, needs to be updated. But one of the biggest problems is it just really hasn't been enforced very often. And the FTC doesn't really have the resources to really enforce it. And I think that's a big problem right there. But we do need better laws as well.
Wonderful. Well, we have about a minute left, so I want to give the other two panelists a moment to, and I apologize, there was one more question, but Professor Goldman, 30 seconds, last note.
Yeah, just to this question, because actually it's a good answer for many of the questions. How should we proceed in terms of protecting our children or our safety? We should proceed with evidence-based policymaking. We need to actually understand the evidence about who's going to win, who's going to lose, what are the costs, what are the benefits, and that's just not taking place. And I'll give you one good example. There's a push across the country to take away social media from minors, to say simply they may not have it whatsoever, or it'll be so legally risky to provide it that you cannot do so and still run a business. And I'll tell you, the minors are freaking out about that because that's not what they want. And we need to understand their needs and how we can best serve them. And the answer may not be what we think it is.
Thank you. And Ashley, last word.
Sure. I think both of my fellow panelists have already brought up a lot of good points on this. So I would just add, I'll re-echo my call for, and something that all three of us have agreed on, that we need a federal data privacy law that I think is obvious to most people. I'll also say, when it comes to protecting children, the one thing that I hope Congress will avoid if it does decide to pass additional laws or update existing laws around children's privacy, is avoiding anything that's going to heavily infringe upon adult privacy, like age verification requirements, these types of things that we don't want to be infringing upon everyone's privacy in order to try to protect children's privacy.
Thank you, Ashley. And thank you to all the panelists for joining us today. And thank you for tuning in, the audience. I appreciate it very much. We will continue to dive into some of these areas, so please look out for some other events that we have going on. But thank you so much for joining us today, and have a wonderful rest of your day.
Thank you.